All things financial planning with a focus on estate planning and fiduciary matters. That is what the Fit for Finance Knowledge Club is all about. Good day and welcome. My name is Albert Fritz. Today I'm very excited to introduce to you a special guest in the person of Moremadi Mabule. Moremadi is head of wills at Sanlam Trust and she has a wealth of knowledge on this topic. She told me that she cannot wait to share that with us today. But before we continue, a very important disclaimer. Fit for Finance is a discussion forum on social media with the intention of creating awareness on the topics discussed. These topics are specialized in nature and advice would be very different for different people depending on their specific circumstances and needs. Before taking any action, therefore, you are encouraged to make an appointment as per the instructions on your screen. At that appointment, your specific needs will be addressed. Now, let's head over to Moremadi. She joins us from the lovely Cape Town. Hi Moremadi, welcome and thanks for joining us today.
Thank you so much, Albert. It's a pleasure to be your guest today.
Thank you very much. Moremadi, let's start from the beginning. Tell us, what is a will?
You know, that is a question that is often asked because when you talk about a will, people start going into panic mode. But a will is a legal document, that you structure it in a manner that is actually dictated by the Wills Act. A will is a document that allows you as a person, we call those people that draw up wills, testators. As a testator, you are able to actually exercise what we call a freedom of testation. And based on that, the freedom of testation, when you sign it properly in terms of the Wills Act, and that legal document becomes your piece of a peace of mind in terms of what you want and what must happen with your assets. So it dictates, it's your last peace voice, if I can call it like that.
Now, I assume most people know about a will. But oftentimes you get people that feel that, they don't really need to have a will in place. Could you elaborate on that for us, please?
It's a common issue. There is a myth around who actually needs a will. One of the myths that we find a lot of times is that people are saying wills are for the wealthy. And the Wills Act is very clear. You'll hear me referring to the Wills Act a lot of times so that we just try and keep it within what the legal framework says. So according to the Wills Act, anybody who's above the age of 16 can draw up a will. So you don't have to be a wealthy person to actually protect your assets and decide who needs to inherit when you pass on.
Okay, now you've referred to the legalities around the will. Can I draw up a will like do it myself, just go to the around the corner and buy a pro forma will?
So, that question, I always say to people, drawing up a will is not a complex exercise. So let's remove, that's another myth, that it's very complex. You need all these other, you need to see an attorney, you need to see a legal advisor. But I always say, going to the shop next door to buy a template and drawing up a will, does it cover all areas that you are trying to cover? For example, does it help you nominate an executor? Do you get an opportunity to nominate a guardian for your minor children? So I always say, DIY wills, I take it with a pinch of salt. However, they are available. I mean, you can even draw up a will online that covers for all those areas. So it's not supposed to be something that is a complicated exercise. But ideally, you want to sit with somebody who's qualified, like a financial advisor. When you sit with a financial advisor, certain areas are going to be looked at. One of the main areas being liquidity. What is liquidity? Is basically to ensure that as much as you're sitting down trying to set up an estate for yourself, making sure that you're bequeathing stuff to your beneficiaries, doing some form of planning, you want to ensure the legal advisor or the financial advisor will sit down and do what we call an estate plan. Out of an estate plan, there will be what we call liquidity calculation, meaning making sure that there is sufficient cash in the estate.
Okay, you've also now briefly referred to the executor, and I guess the executor is a very important person when it comes to the winding up process of an estate. What are those roles and responsibilities?
So an executor is a very important role. Remember, a will, you're drawing it up while you are still alive. And when you've passed away, somebody is going to step into your shoes, try and close all those admin issues and your obligations that you had. One of the responsibilities that the executor is going to be doing is to ensure that they liaise with beneficiaries, they liaise with creditors, they collect all the assets, they do an inventory, and then from there, based on what you've set up in your will, they'll do what we call a transfer and bequeath. If you've made bequests, then they actually give those legacies to the rightful heirs. So the role of an executor is very important, and choosing one is also equally important, because you don't want to choose someone who's going to second guess themselves. I want to highlight one point, what the master says. In terms of the master's processes, you have, if the estate is more than 250,000, you need to get an executor to do the winding up of the deceased estate. So if your estate value is actually that amount plus, definitely nominating your friend who is a teacher might not necessarily be a good idea, but how that process will unfold is that he will go to the master. The master will say, we recommend that you get somebody qualified to assist you with winding up the deceased estate, and then they go and they will get the letter of executorship. However, they must nominate an agent. So that's what we call power of attorney. So they'll give a power of attorney to the agent. It can be a bank, it can be a financial institution like a trust business. And once they've giving them the agents, then they act on their behalf in terms of winding up the estate. However, when you're doing up a will, and you're nominating an executor, you've got an opportunity to nominate somebody who's qualified to do that already.
Okay, Moremadi, what are the important factors that I, as a client, need to consider in the appointment of an executor? Or will the Master of the High Court just lead me in this process?
So the Master of the High Court, like I said initially, that they will look at the estate value. If the estate value is more than 250,000, the master will recommend that you go and get somebody to assist you. So, the family at that point in time, they will be running around trying to find somebody to assist them on a power of attorney basis. And one of the important things that you want to look at when you are appointing somebody to act as an executor, you want a reputable company or a reputable institution. I always caution against one-man shows. And I'm not saying there's anything wrong with them. If they are specialists in that area, great. But you also want to ensure that there is security in case something goes wrong. So, a big brand normally would be ideally the kind of executor that you want to nominate, just based on the fact that should something go horribly wrong, you will be protected.
Okay, now we also know that life is costly. So what can I do to try and alleviate most of the cost in terms of death? Because I know most people don't ever consider the cost when it comes to dying. What can you tell us about that?
So, that reality is dying is very expensive. We thought living was expensive. Dying is very expensive. And it's an expense that you leave, unfortunately, to your family members. And some of the conversations that I always have is people who will be shocked to the extent of the executor's fees. They'll be saying 3.5% of the net. That is quite a big amount. I mean, where do I get that kind of money? And I always say, when you've done, an estate plan, and you've sat with a financial advisor and they did a calculation for you, you are able to plan for that expense. So the 3.5% on the gross value of the estate is a regulated fee that you go to an attorney, you go to a bank, you go to a lawyer, you go to a financial advisor. That's exactly what they're going to charge. But how do you plan for it? Is creating enough liquidity in the estate. But there's also some of the things that you can do. You can always negotiate with an executor as you are nominating them. You can negotiate to say, you know what, look at my estate. It's this amount. Can we strike a deal here? And I know some organizations are actually open to negotiations, and based on the work that they are going to be doing. So, what are the tips that I could give you? Is if your estate is quite sizable, and it's quite straightforward, and there is enough liquidity, definitely you can negotiate that get a rebate out of that 3.5%, because that is quite a big amount. However, planning is important. Executors' fees is not the only expense. Like I said, dying is quite expensive. What are other expenses? We like it or not, the tax man also knocks. If your estate value is above 3.5 million, if you are a single person and you've got an estate value above 3.5 million, then we're talking about estate duty. If you are a couple, we're talking about 7 million estate duty, which is going to be applicable. That amount is due and payable, so you need to plan for it. When it comes to a couple, that 7 million, there's a rollover effect. So that you somehow the first dying can escape that amount. However, planning for it, and the only way you plan for it is if you sit with a financial advisor.
Thanks, Moremadi. Yeah, the expenses are quite scary, and those are things that we normally don't think about, eh? Or is it that we don't want to think about it?
Definitely.
Yeah. Moremadi, you've now often referred to liquidity. What is liquidity, and why is that important?
Liquidity is basically cash, cash in the estate. Remember, I explained the fees that are expenses to the estate, the executor's fees. I also referred to estate duty if applicable. But some of the things that I didn't touch on is sometimes people will do cash legacies, the cash bequests. Where are they going to come from? And people with minor children, they would be, ideally they need to set up what we call a testamentary trust for the minor children, meaning we'll have a trust set up that the children's inheritance will be looked after. Remember, in South Africa, you cannot have minors receiving cash in their bank accounts as an inheritance. So it goes to the guardian's fund. But if you cater for minor children, you put it ideally in a trust. But running a trust is expensive. So you need money for all those exercises. You cannot set up a testamentary trust and the only thing that you've left for your children is just a fixed property. What's going to happen to them? How are they still going to continue? So those are some of the liquidity or the cash that you need to cater for and provide in your estate.
Okay, thanks for that. Moremadi, what would you say is a realistic time frame for the heirs to expect an estate to be wound up?
Sure. During COVID times, we've learned other things. We were affected in all areas. The fiduciary industry has been affected. So I'm going to touch on the realistic expectations of the current situation, so that we manage expectations when we're dealing with people, and people understand that if somebody has passed away, it's not an overnight transfer that's going to be happening. It's a process. And I'll touch just a little bit on the process so that people understand when I say it might take a year, it might take, slightly longer than a year. What do I mean? Okay, normal environment before we had COVID, pre-COVID, what was happening is that as you get all the documents, you submit it to the master, you had 30 days to get what we call letter of executorship. And we all know now the master's office is dealing with backlog. I don't want to repeat what was written it was common cause, it was in the newspapers. But now, because of the backlog, everything is so delayed. It's by luck if you were to get your letter of executorship in 30 days. We don't get it in 30 days anymore. Meaning that whole process now is actually now stretched. Let's say we get the letter of executorship in 3 months. then the process only starts moving then. And then it can move. And you've got other stakeholders like SARS, you've got the banks, you've got, there's a lot of other stakeholders. So ideally, if you're lucky, we're talking 9 months in a normal environment, but now we've stretched it to 12 months. And you know what? It can easily take 18 months for a relatively easy estate.
Okay, I think we are all on the same page now and we understand the importance of drawing up a will. Who do I approach to help me, Moremadi, and how do I prepare for that appointment?
Yes, I spoke a lot about the financial advisor, and I always give a story around why I am pro financial advisors. Is we've got family doctors, we've got family attorneys, we've got dentists. Why don't we have financial advisors, somebody who's looking after our finances as we plan and we move forward? I would say approach a financial advisor. They will be able to assist you because they don't only just look at what planning for retirement and planning for education, children's education. When they sit down and do a proper estate plan, meaning they go through the entire asset base, they go through the entire, your wishes altogether. And based on that, I would say when you prepare for that appointment with your financial advisor, what you need is you would have decided, firstly, in terms of your assets, who's going to inherit. If you've got businesses, you would have thought about, buy and sell agreements and stuff like that. Who's going to actually take over from you? I always say, think of a will as a document that helps you to do what we call succession planning or legacy transfer. You're passing on this wealth to the next generation. So have your asset base in mind, understand your asset base, have a conversation with your spouse if you guys are married in community of property so that it's all aligned and makes sense from an executor perspective. The last thing, if you've got minor beneficiaries, if you could have thought about who's going to be a guardian for your minor children, which is something that we sometimes, forget to do. And when somebody passes away, there's always, that debate, what needs to happen to the children. So those are important conversations. So go there prepared because we're talking about you now putting everything for the last time, on paper. When or should something happens to you, this paper is the one that's going to be speaking on your behalf.
Moremadi, thank you very much for sharing a lot of valuable information with us today. I think all our viewers now have a better understanding on wills and they are ready to take action now. Thank you.
It's a pleasure. Thank you so much.